Hi everyone, it's Grant Abbott speaking, and welcome to this was a very special event for me. From my perspective, this is probably second only to the Protector in terms of practical relevance for anyone in Australia that is a director, particularly probably not a public company director, but certainly any other directorship for your small business clients, anyone with a discretionary trust with a corporate trustee, anyone with an SMSF with a corporate trustee. The only solution to me is either the successor director, which we'll have a look at. In our EPOA, we've also got successor director solution and also our leading member, which is a great solution, but probably is more attuned to bankruptcy there. So we'll go through each of those solutions, when to use it, when not to use it. I'll take you through our new successor director solution. I'll have to show you in the back end in what we call the hub. I've just got to tweak a couple of little elements there. We just had a bit of a formatting problem, but I'll show you what we've got. And we're just loading up all the changes to the successor directors because essentially in order to put this solution in, you're going to have to ensure that your corporate constitution or your association and also your constitution has a successor director solution in it. So we're going to have a look at that. I'm also going to show what our solution is, which will encompass not only the asset guide, which I'm going to take you through shortly, 73, but also include binding resolutions for each and every company. Plus also will include a corporate constitution upgrades as well. So that'll all be done in one solution. So let's go down and again, I think if we have a look here, this is where we're sort of heading. You've got the little Buzz Lightyear, our little mascot. I would say LightYear Docs and Abbott-Family, and probably another one there is hat tip to Tim. I mean, he's obviously a very important part of the whole equation around this strategy side of things. So if you're not supporting Change GPS, make sure you have a really good look at that, because with our back end and Tim's front end, as we go into 2021, it's a no holds barred solution. So it's very exciting. I think 2021, I think for a lot of businesses, it's going to be very tough. So this solution that we're doing really should be offered to absolutely everyone. And I'll probably get Tim, if you want to put a letter up or something up on a Change GPS for this strategy or this solution to be awesome. I think I'll certainly do an email out and about for it. Again, Tim, hat tip to Tim, and it's not only this one, we've also got a couple of other really important asset protection documents coming up. And I think that that's absolutely crucial that, as we go down the track, we're starting to provide a significant amount of breadth in terms of our asset protection. And this successor director is absolutely crucial. A question that Tim asked me, and he sends me a lot of stuff. In fact, if you saw a couple of things that are coming up, you'd be blown away. But we will introduce, and probably the first start, we'll introduce them next week at our Gold Coast 3-hour workshop. But Tim asked me and really made me ponder what would happen to a business, and that includes me, where the founder and prime business mover gets COVID, is sick, goes to hospital, is stuck there for months. I know from my own perspective is that I'm a director of obviously the LightYear Group. So I've got other directors who would carry on in that instance. Though if you have to have a look at it, the issue about that is I'm a significant shareholder in the LightYear Group, which includes LightYear Docs and I Love SMSF. Again, if I get sick or incapacitated or something happens to me, it's nice to have the other directors there, but I want to make sure that there is someone, let's say it's a Tony Anamoulis, my partner, is actually appointed as a director representing my interests as a significant shareholder. And I think that's important, is that we're not just looking, and I'll show you the asset guideline very shortly, which deals with sole shareholder, sole director, but really it should be expanded to anywhere where our interests, our financial acumen, our wealth, and our obviously continuity of investment is tied up to our directorship. Essentially, we want to make sure that someone is in there representing our interests. And this could be, for example, just a simple unit trust that, if I had a look at, say, Tim and I, we've got a superannuation unrelated investment trust. We're both directors of that. What happens if I'm incapacitated? Well, do I want Tim? I love Tim, but to him to control the whole process, I need to have someone in there representing my interests. And obviously with Tim, I wouldn't have to worry about that, but I think it's absolutely crucial for that. So this successor director issue is far bigger than many of us would expect. And if we go down and have a look at it, continuity business, deals, contracts, bank accounts, etc. I just pulled this stat that using employment measure of small business, there's over 2 million small businesses in Australia employing less than 19 people. Most of those, apart from sole traders, obviously will be corporate or corporate within a trust. So we really need to be looking through our database. And this is probably the first thing I would be doing. Forget about wills, forget about enduring powers of attorney. They're crucial. I'd get this in play because this can have a significant impact on your clients. And also make sure you put it in line for yourself as well. Absolutely crucial. So it's again, what it's all about is by having that successor director, effectively what we're doing is we're ensuring there's a moat around the castle. Look at it, for example, I'm not going to have that problem with my SMSF, and I'll talk a bit later on, but if you've got a SMSF, we're the sole director of that SMSF, and also potentially the sole shareholder, or it doesn't matter even if there's numerous shareholders. What happens to that in the event that you're incapacitated? Or more importantly, what happens if the trustee in bankruptcy, you go bankrupt? What rights and entitlements does the trustee in bankruptcy, he'll start to attack that company, as they should, in order to access, obviously, your discretionary trust. They can hold that in place. So we've got to be very careful about all of this. And it seems to me as if we haven't put this in place, there's no moat there. We've virtually just got a red carpet right up to the front door with the gate of the castle open and allowing lawyers, litigators, regulators and trustees in bankruptcy full carte blanche to access the castle and plunder our wealth. So if we have a look around here, this is our typical moat structures. So a lot of these you'll see as we go through. So I've got leading member trustee company for discretionary trust, leading member SMSF trustee company, leading member trustee company for the family protection trust. And we are building a special corporate trustee, Tim, for the family protection trust, which will go up in the next day or so. And then obviously we've got our executors and wills and testamentary trusts. You've got the bucket company there. We haven't got a leading member situation there. So that bucket company, again, is rife. If something happens, who's the director of that bucket company? Now, this is already imbued with a lot of the solutions here that we'll see going down the track. But for all of those who've just got standard discretionary trusts and standard SMSFs, those corporate trustees are really open and prone to attack. So when we have a look at it, the key issues that we're facing is obviously trading companies. If we're running through a trading company, there's obviously going to be business continuation problems if something happens. Secondly, if you've got bucket companies, if they're locked up, subject to litigation or incapacity, who's actually going to be passing out that cash flow? It has impact on wealth, loan, and obviously cash flow issues. Discretionary trustee companies, both investment and business continuation, obviously is a concern. I talked about the SMSF. And as I said before, if you've got unit trust or companies and you've got a representation in there, it's absolutely crucial that your interests are looked after. And I think that is absolutely crucial there. When we go down the track on this one, there's actually a provision in the Corporations Act. So I'll go through the provisions, then we'll have a look at the ASIC regulatory guide. So Section 201F of the Corporations Act talks about, and this is only, when we go up here, this is only one small part of the entire issue, but it's an important part. So there's special rules that are actually laid down for the appointment of directors for single director, single shareholder proprietary companies. So subsection 1 says the director of a proprietary company who is its only director and only shareholder may appoint another director by recording the appointment and also signing the record. Now, if you're appointing a successor director, we'll go down to the next section, but obviously that's pretty obviously subsection 1 is just pretty traditional there that you can appoint another director. Secondly, the appointment of new director on death, mental incapacity or bankruptcy. So this is where the rubber really hits the road. So the first one is if a person who is the only director and only shareholder proprietary company dies or cannot manage the company because of the person's mental incapacity, and a personal representative or trustee is appointed to administer the person's estate or property, the personal representative or trustee may appoint a person as the director of the company. So that's fairly important to make sure that you have those EPOAs. You obviously will talk about the LightYear Doc solution, but it also means that the executor to the estate has the power to appoint someone as a director. The only issue that you have there is obviously the timing around that. It's far better to have a successor director automatically appointed rather than if someone dies. This could take, for those who've been involved in estates, and I'm currently involved in my dad's estate, and I'm the executor, and this has been now 2 months, and I'm just going through that probate process now. So you've just got to be very careful about that timing. It could have a significant impact on the business or the underlying investment. So the appointment of a new director, when it comes around to bankruptcy, there's a big issue here. So sub 3 basically says that if the office of the director of proprietary company is vacated under 206(b)(3) because of the bankruptcy of the director, and the person is only director and only shareholder of the company, and a trustee of bankruptcy is appointed to the person's property, the trustee may appoint a person as the director of the company. So if you consider that, particularly if you've set up a corporate trustee for an SMSF or a discretionary trust, that can create a huge problem because prima facie, they've got the right entitlement to put a director on there to look after their interests, notwithstanding both a discretionary trust and also the SMSF are both protected or asset protection if you've seen that session that we've done, but it still gives them a way of inveigling their way in. And the thing is, if they're able to put that in, they can put themselves in and effectively create havoc. And if you can lock up a discretionary trust, if you can lock up an investment, an SMSF, then you're in a strong negotiating position. I think that is absolutely crucial. I have seen instances where, discretionary trusts have been locked up on a death of a testator, and there was a family provisions claim. A lawyer, a very aggressive lawyer, took action against the executor and made sure that the executor who had appointed themselves as director of both the discretionary trust and SMSF would not do anything or could not do anything without their say-so, which brought obviously negotiations to a head and was quite a scary instance. But if we've got that scenario, then we're well and truly on track. So there's 3 LightYear Doc solutions. They all marry up with section 201F. In fact, before I do that, we might just bounce out of here and I'll have a quick look at Asset Guide 73, so information guide, which I'll send out to you with this pack. So this afternoon, you'll see this will be actually up on the website. So for successor directors, and that'll include obviously the slides as well as this asset guideline. This asset guideline will form part of our successor director pack anyway. So importance of sole company directors or shareholdings having a will. Why do directors need a will? And this is quite an important aspect. So if you're going down here, and I'm sure, Tim, you're probably already starting to think about that, is that not only is the successor director solution really important, but the client needs to have an enduring power of attorney when it comes around to incapacity, but also needs to have a will, and all of these things are catered for. So it's almost a one-stop shop, a package where you can put the whole 3 together, and definitely we'll be putting that successor director in the moat and the castle. So why do directors need a will? Difficulties can arise when an ordinary person dies without leaving a will. Their estate, let me just put this up a little bit higher so you can see it. if you're like me, there we go. Their estate cannot be quickly wrapped up, and dependents, widows and children can be left waiting lengthy periods before either the state or territory public trustee steps in to manage the estate or letters of administration granted by the court to someone else to administer it. You're looking at probably at least 6 months, But when a sole director of a company dies without leaving a will, the complications and distress can have an even greater impact. The death will usually leave the company without any person properly authorised to immediately manage the company. Ordinarily, if a director of a company dies, the surviving directors can continue to manage the company and may even make a temporary appointment, pending the appointment of a new director by the member shareholders of the company. So that's not a bad thing, but again, we want to make sure that someone's in there representing our family's interests rather than surviving directors. In fact, there may be a conflict the other way around. The surviving directors may end up doing a coup or a takeover or seeking to take advantage of the loss of directorship. Equally, if the sole shareholder of the company dies, the directors can continue to manage it until the beneficiaries under will have the shares transferred to them. So there's obviously a big timing issue here. Where the sole director is also the sole shareholder, however, the risk of uncertainty is much greater, as you can expect. Certainly the two above, I'd still want to make sure we've got that, that successor director or the leading member. Well, obviously you can't put a leading member if there's a multi-director there. So successor director is important. Where the sole director is also the sole shareholder, the risk of uncertainty is much greater. Section 201F of the Corporations Act does provide that in the event of the death of a single member director of a proprietary company, the executor or other personal representative appointed to administer the deceased estate may appoint a new director of the company. The director has all the powers, rights and duties of the deceased director and can keep the company running until shares are transferred to beneficiaries who may then appoint new directors if they wish. As mentioned above, the executor is ordinarily most efficiently appointed by means of a valid will. So again, to get that, you've still got to go through that probate process. We can take anywhere from 3 to 6 months. And look, if the will is challenged, it can take a lot longer. Where there is no will, however, a near relative or other person would have to apply to the local Supreme Court for letters of administration to manage the estate, and this could take some time, possibly weeks, if not months. Alternatively, in the absence of any immediate relatives or other obvious people to deal with the estate, the public trustee may step in and administer the deceased estate, but this process can also take months. During that period where there's no director, the company may be completely unable to operate. With no one properly authorised to make management decisions or act for the company, it may be unable to trade. Banks and other financial institutions in particular may be willing to accept instructions in relation to company's trading account if they're not satisfied there is someone properly authorised to act for it. Absolutely. Equally, staff and suppliers may not be able to be paid, which can quickly have a deleterious effect on the reputation and value of the company and beneficiaries of the estate. If you're not getting the gist, I mean, really all your clients should be reading this. This is not me, it's not Tim, we're not scare campaign. This is ASIC telling us, giving us a heads up what's important. If, on the other hand, a person is willing to purchase the company, they may not be able to do so quickly because there will be no recognised owner of the shares who can authorise their transfer until the testator has been appointed and settle the estate. That should actually until the executor has been appointed, so it's a typo. Even if the final decision taken to wind up the company so all beneficiaries can be paid out, the delay of possibly several months may mean the value of the company will be much less than it might otherwise have been if it had been able to continue operating in the interim period. So what makes a will valid? To be valid, a will must be signed at the end by the testator or by someone authorised by him or her, and the signature must be acknowledged by the testator in the presence of at least 2 witnesses who are not also beneficiaries under the will, who must themselves sign the will in the testator's presence. If a sole shareholder director of a company, you should have a will as recommended that in this will you make provision for who is the beneficiary or beneficiaries of your shares. So the successor director solution is a great solution in that interim period until the executor takes on. So you can start to see, this is why I'm saying this is an absolutely crucial a document for me because it applies now. Jimmy, this is COVID we're talking about. This is actually applying now. So we need to have a look for this. Tim just said he's starting to create a value price plan email advice around this now. Absolutely every client needs this now. And absolutely, I agree with that one. Should have made you a panelist, Tim, but we'll definitely be talking about this next week. It's absolutely crucial. So let me go through the three solutions that we have on our platform. You may have already seen, and this is really interesting from a legal perspective, and I just want to take you through it. You may have seen in our EPOA, which I'll show you a little bit later on, that the enduring power of attorney can be appointed to be the obviously the successor director of a company in the event of incapacity. Now, that is actually embedded into the EPOA. That flows into obviously section 201F, but needs to be evidenced by the Constitution as well. An EPOA essentially cannot appoint a director. Obviously, that has to be a constitution thing, mainly because an EPO is state-based law, whereas when we have a look at we've got state-based law, whereas when we have a look at companies, we're dealing with federal law. Importantly on that, there was a recent case in the New South Wales Supreme Court, G versus G, talking about EPOAs, what they can and cannot do. Interestingly, out of that, if there's specific provisions for things, for example, you can have specific provisions for appointing directors, provided the Constitution allows it. If that's covered in the EPOA, then you're okay. In that case, in G versus G, it was whether the EPOA can actually do an SMSF will or a binding death benefit nomination for the individual concerned when they've lost capacity. In that case, it was held that it was problematic, but to concrete it in, it would need to go into the EPOA. So we're now starting to build that capacity into our documents so that if you want the EPOA to create or change the binding death benefit nomination or our preference SMSF will, that will be built in there. Again, we're the first one to build it into the EPOA. So it's been there probably around about 6 or 7 months. Our another solution, which I think is a better one for bankruptcy, because the first one, the EPOAs, I mean, if you've got a company, you might obviously be able to be appointed there, but if it's going into bankruptcy, then obviously the solution is probably not the best because the trustee in bankruptcy are going to come in and appoint a director anyway. However, for the leading member trustee companies, such as our SMSF trustee company and leading member of family protection trusts, the basic solution there is that the leading member is obviously a director and also appointer of the trust, or is the leading member of the SMSF and holds the only share to that company. Now, importantly from that one, if we have a look at it from a bankruptcy, incapacity, divorce, and also death solution, with that one, what happens is if a leading member resigns, gets divorced, is incapacitated, dies, or becomes bankrupt, then what happens automatically, their directorship ceases, and then the next leading member comes in and takes their place anyway. So we've put in place a different solution. So it encompasses not only the successor directorship, but also includes a transfer of the shares. So the shares immediately go from the first leading member to the next successor leading member. And I think that is absolutely crucial because that helps us around that bankruptcy issue. Does that make sense? So I love the leading member for bankruptcy. The only problem about that is that if you've got a trading company, leading member may or may not be appropriate. And certainly if you've got an investment in a unit trust or you've got other investors, leading member is probably not going to be the ideal situation. Now we also have our standalone automation, which is our successor director solution, which includes binding resolutions and upgrade of the company, which we're going to have a look at. So I'm just going to go through here. It's fairly important. We've chosen the alternate successor director rather than alternate director. And really, let's go through both sides. So alternate director, do you need to notify ASIC? Yes. Successor? Yes, obviously, because they're fully fledged directors. Power to sign a circulating resolution? Well, they're both directors. Yes. Power to vote at meeting? yes, but again, if you've got an alternate director, a successor director is a true director's appointment, which is absolutely crucial. Count as part of the total number of directors? No, because you're acting as an alternate. Yes, as a successor director. So that's really important for quorum. Must be a director to act in the role? Yes, no for alternate. And does the position cease if appointing person loses capacity or dies? And that's yes for alternate director, but no for the successor director. So that's absolutely crucial. So the successor director is far better than the alternate director, is why we've chosen that solution. So let's have a look at the company constitutions, which we are going through the process and replacing now. So for all our constitutions, but you'll see for our SMSF and discretionary trustee companies, any member who's a director may seek to appoint a successor director as a replacement director who's to take the director's directorship in the event of the director's incapacity, bankruptcy, death, or by their own choosing, provided such an appointment does not breach the superannuation laws. So if there's obviously a creditor's petition out, you can bow out and put a successor director in, but knowing, of course, that at some point in time, the trustee in bankruptcy is probably going to come in and give a bit of a smash on your head anyway. So that's better to have that leading member solution if that is possible. So I'd always go leading member for SMSF and discretionary trustee companies. For ordinary companies, then we've got exactly the same, notwithstanding Rule 45. The directors at the request of the director may confirm the appointment of a successor director is to take the director's directorship in the event of director's incapacity, bankruptcy, death, or by their own choosing. So that is now embedded in all our corporate trustee upgrades, which I'll show you a bit later on. But it also embedded in all our brand new establishment companies as well. So that will just be part and parcel of all of our suite of companies, which is probably a better way rather than having to get lawyers to go in. And anyway, if you've seen lawyers doing successor directors, they charge a fortune for that. The successor director in the EPOA, you've seen this before, we won't go through, but you can see here, act as a successor director where the principal is a director and no longer willing to act as a director through incapacity, death, or their own choosing. So that's, for example, divorce, etc. So if you look at separation, you can pull the pin on that one. The important one here is, as you can see, it's not just for the sole director or the sole shareholder. Obviously, this can't impact the shareholding, but it's not for sole director. So you can use this again for any company where you're acting as a director for. Obviously, Section 201F won't apply, but you'll need to make sure that the company that you are dealing with, if it's say a trustee of a unit trust that you've got an interest in, or a trading company, you need to make sure that they have that successor director solution in there. It's absolutely critical, or upgrade it to our one. So let's have our successor director solution. I'll show you. Contains the ASIC Information Guide 73. It's not just for sole directors and sole shareholders. So it's actually for multi-directors. It provides a binding director's resolution to be signed to appoint a successor director in the event of incapacity, death, divorce, and potential bankruptcy. Sorry about that. So I'd go to choosing a leading member. Sorry about these. I'll make sure I'll fix these up before I send them out. So you can do multiple companies at a time, which I think is exciting. If the current constitution does not enable the successor director, then you can upgrade the relevant company constitution. So our standard companies, as I said, will have a solution. Suggested advisor fee is anywhere from $750 to $2,500 per company, depending on the company, and also the size of the company, whether it's just a trustee, and more importantly, whether you have to upgrade the solution. So that's mine, but I know Tim will come up with, so you can have multiple EPOAs, absolutely. So you can have an EPOA, which is important just for successor shareholders. So that is a really good question on that one, particularly now you have a look at G versus G. It's a really important one as well. So it now enables us, which I've always believed has been the situation, but now we've got legal authority, which cements the fact that you can have EPOAs just for specific circumstances, such as appointing a trustee as a replacement trustee or director, or alternatively, the successor director. So let me go through and let's go in and have a look at what our solution is. As I said before, this will be released tomorrow or no later than in the next couple of days. I just have to go through and check all the permutations. So what I'm doing at the moment, this is the back end. So you can see this blue frame here is what essentially you work on when you're dealing with LightYear Docs. This system now, so what it'll do is I'm just going in, testing it, and then that'll be up and running. But this will give you an idea of how we do it. So what we'll do is we'll just put trustee companies, successor, just so I can find it in the folder. I'm going to put the AM001 tag in here. When you go down here, this is all corporate stuff. So it's replacing the Constitution under Section 137 of the Corporations Act, which is the shareholders of the trustee can replace the Constitution. So if you're going down that leading member, you've got a couple of shareholders, cancel one set of shares and just leave one single shareholder and then make them the leading member and upgrade from that perspective. From that perspective is you won't need to, you can put the Abbott-Family logo on, but equally you could, for example, have the Change GPS logo in there, which is absolutely crucial because you're not providing legal advice. As you will see, there's no legal service on that one. This will be bulked out a little bit, but let's say we're doing this from tomorrow. Okay, so these are the general details. This is when it's going to apply. So we've got a company there. So let's go through the first one. We'll put change a lot, and then we go through the PTY Limited, put in the ACN. So we don't need to put all the registered office in there. Current director's name, John Smith. We can, we can use this for multiple directors if we want. The successor director is Jane Smith. And if we want, we can have two directors. So I could have Max Smith as well. Now, this is the chairperson. This is not for successor directors. They're not appointed yet. So we need the chairperson from the current meeting. So this is John Smith. Now, what we need to do is, if you're not using a current LightYear Doc company, then we need to upgrade to a LightYear Docs company. So we can go add another. Now, we've got a drop-down box. Let me just go down a ways here. So with the drop-down box, I've got 4 choices there. I've got the company constitution to a leading member SMSF corporate trustee. So that's the leading member one. Company constitution to a LightYear Docs SMSF corporate trustee. Discretionary trustee company upgrade to leading member trustee company, or LYD standard company upgrade. So I'll need to have put a couple of more in there as well. For example, the Family Protection Trust company as well. And if you can think of anyone else, let me know as well. So let's just go through, and what I'll do is I'll just choose the ordinary LightYear Docs SMSF corporate trustee. Now, to use a Section 137, I need to put in the shareholder's name. So all the shareholders in a members meeting agree who this new director is. So that's it. So for that company, it's all done. So I've got another company, and this time it's going to be my family trust nominee. So this is the company, obviously, for my trust. Current director, again, John Smith. And then in this instance, I'm going to make it the son, Max Smith. So chairperson, again, John Smith. And then I'm going to upgrade it. And this one, I'm going to use the leading member trustee, discretionary trustee company. So I need to put that in place. And again, it's just going to be John Smith. Now, what I'm going to do is I'm going to add another here. So you can see how I can do it. So this is Bucket Company, PTY Limited, put all this in here. As you can see, this automation is quite powerful. If you went to a legal firm and asked them to do all this, first off, they'd have to research what to do. And secondly, they then have to build all this documentation for both of you. Again, John Smith. So this is just a standard company constitution. So I'm going to use that LYD standard company upgrade. And again, for John Smith. So I'll now finish that and produce all those documents. So it's just going to take a time because we're going to end up with 6 documents. So shock. So if the current constitution is silent about the alternate successor director, we can't appoint a successor director. That's correct. And even if you saw section 201F just says this is what you can do, you still have to have that constitution that has that. So which is why I built those constitutions in there. So you can see here, this is pretty obvious for you, but you can see when I'm using this hub that I obviously pick up the Word doc, which is a little bit different from where you are in terms of using LightYear Docs, which comes out as a PDF. So let's go through. As I said, this is just the third time I've used this. So there's a couple of tweaks that we've got there, but it's starting to look pretty good. The main one is obviously to, as Ashok said, so if we have a look at that, it's important. So Troy Doodle, I mean, how's everything going up in Lincoln there, my friend? How more complicated is it with a family trust shareholders? With the family trust being shareholders, that's not a significant impact. Where you've got, if it's a bucket company, then obviously you can still use that successor director. But if they're the shareholders, the family trust, then you're going to need the corporate trustee. So that's an important one. I'd have to go in and have a look at the directorship of that corporate trustee. So that's a really good point, Troy. Let me go in and get my mind around. Are you talking? Just come back to me. You're looking at bucket companies there. So that's a really good question. So successor director solution, obviously got the Abbott-Family sign off. Resolution by the company to appoint a successor director in the event of the director's incapacity or death. So we've got there, to ensure the continuity of company decision-making, directors seek to appoint a successor director for the current director where they lost their decision-making capability, die, become bankrupt, or otherwise choose to do so. So I'm going to have to just change that headline a little bit here, as you can imagine. Obviously there, that has to be for any other reason, so that'll happen. John Smith, with John Smith acting as a chairperson. The chairperson table a motion to appoint Jane Smith and Max Smith to act as successor director when requested by the current director. We go through the process and then it's signed off. So that's our successor director binding resolution. I would say that it's probably important for you to keep a copy of it, the signed resolution, and make sure obviously the client does as well. So we've got constitution upgrade to SMSF special purpose corporate trustee. We go down here. Obviously, we need a special resolution by the members to upgrade the constitution. And then we end up with that special purpose corporate trustee. So that goes down the track there, which is important. Then we go down and I think I'll just check. I'm not sure if our guy is still here. So you'll see here. Okay, so we've got the member legal disability. We've still got 5.1.4, which is going to be included in this. You've seen the copy on that one. So that will be included. My team's putting that in at the moment. So we then go down, we go to the next one. Okay, it looks as though, unfortunately, it looks as though my guy is working on it. So that's why, it looks as though we've got it. Sorry, I've just gone too far. Okay, so I've just pulled it too far. So you've seen the SMSF one, so that's okay. Okay, so this is the next one that I've got here, resolution by a company to appoint a successor director. Then you can see we've got the renumbering of the pages there for you, Tim. Constitution upgrade to leading member corporate trustee. So that's in there as well. And then we've got the final one, which is our bucket company. So we've got the bucket company there as well. And then that goes into the upgrade of the standard constitution there. I'm not sure, again, I think he's just in the process, should be 45.4. So it looks as though we're still in the process of uploading all of those ones as well. Okay, yes, so you've got the personal representative, so that covers that. We've got a new one, 45.6, which will then apply then. So all of those will be up and running, but as I said before, I'm expecting, I'll have a look at that. I'll just get my head around that family trust being shareholders, Troy. But expect this to be up and running certainly by no later than Monday. In fact, it should be up and running and up on the system by tomorrow. I've also got a couple of other documents that are coming up on the system. I've got an assignment of a loan and debt. I think I showed you, I just haven't put it up on the system yet. And we've also got the vesting or the wind up of a unit trust, which is sitting in there. So essentially, this is our new solution. Again, go back. I'll send you out the slides. The key ones for us are the three solutions. You've got the EPOA, which, as we said, it's quite specific, marries up the law under G versus G. We've got the leading member, which is my favorite because it sort of covers bankruptcy and really pushes it out. It's also great for divorce, etc. But now we've also got the successor director solution. If you need any help around which one you should use, again, we just get on support ticket or contact me by email or by phone. Most of you got my phone, and we'll take it from there. But anyway, with any further questions, hopefully for those of you in the Gold Coast or Brisbane, we will see you next week. It's going to be so much fun doing a face-to-face event again. Zoom meetings I love, but I want to get out face-to-face, and we're going to put on a great show. Anyway, it's Grant Abbott signing off, and thank you all for attending today. Great session for all of us.